Okay, we're now recording. Okay, so the first thing to confirm is that the final test is next week, and it is on the same time as this class. It's on Monday. So I can give it to you guys a little bit early and give you kind of the day to take it whenever you want. So you can click the link on Blackboard. And so I'll put it up, in the morning and take it down at midnight. That'll be the plan. So, and then if anybody has a problem with Monday, I guess I'll make it available. It shouldn't be all day. Maybe I'll make it available at noon and take it down at midnight, 12 hours, that's already really too much. But for this semester, I'll do that. And then if anybody has a problem with that they need it earlier, I think somebody had said they had a problem, but I've gotten confused from all this messaging, then people can reach at me. So if anybody sees this on the video, the test is on Monday, December 28th. It'll be a link on Blackboard in the content section that will say final exam. When you click the link, you'll get to a new page and you can press start. And whenever you press start, you'll have 3 hours. When the 3 hours are over, it will automatically be submitted. I'll say that again. When you press start after 3 hours, it will automatically be submitted, which means if you write it on a Microsoft Word document and 3 hours are over, it's over. It's automatically submitted. So you need to make sure you watch the time, and at around 2 hours, 45 minutes or so, take the information from your Microsoft Word document, copy and paste it into the text box on Blackboard. I strongly recommend that you do not write the test on Blackboard. I recommend that you open and immediately save a Microsoft Word or some kind of Microsoft word processing document, write it on your computer in the word processor, and then copy and paste it to Blackboard. And just make sure you leave yourself, 10 minutes or so at the end to copy and paste it, and just make sure there's, you fix any formatting problems you may have. So if anybody has a problem with the time or any concerns or questions, just let me know. Are there any questions right now? No? Okay. Okay, so then we have that set.
Yes.
Sorry?
Is it on the 28th at the end, the exam?
Yeah, it'll be on the 28th, a week from same time as class, except you don't need to come to class. You can take it whenever you want that day.
Okay, thank you.
Just go to Blackboard and click the link in the content section.
But the other people who will do it like at the same time, you will oversee us, and we will do it together, kind of, right?
No.
Okay. Everybody do it at the same time.
Yeah,
okay.
Everybody can do it whenever they want, but it will only be available next Monday.
For 1 hour, 2.5?
It will be available from noon,
to
12 o'clock,
midnight. But
to midnight.
I'm talking about like the length of the.
The length of the test will be 3 hours.
3 hours? Okay.
3 hours.
Damn.
I would expect you don't need 3 hours, but I would expect you probably do need at least 2, probably 2.5. If you are taking the test and you are done after an hour, you have missed something. Okay, so let's start going through some of the practice tests that I gave you. I gave you practice tests in all of the questions in all of the subjects. Are there any questions before we begin? No? All right. Well, let's look then at the contracts test or practice question first, if there's no preference. Let's look at contracts practice question 2, in case you guys haven't done that one yet. Okay, have you guys, have any of you looked at this one or done this one yet?
I haven't seen that document before on Blackboard.
I'm sorry, what? You haven't seen it on Blackboard?
Is it in Word format?
Hold on.
There is Word format and PPT format.
Let me share my
It-
screen and
it-
show you where it is on Blackboard.
It is in the Blackboard.
In Blackboard, in the content section, week 15, final review plus practice tests questions. It's been up all week.
Okay.
And
Thank
in
you.
here, there is all contracts 1 and 2, agency, company law, and employment law. Each of them with a question and PPT answers. So that's what we're going to go through now. So we'll start with contracts question 2. And I will say that the final exam is like a combination of all of these. It's kind of like all of these put together. So let's read this. Chris runs a local small business selling furniture. Last week, he placed an ad on a local website that said top of the range Italian leather luxury 3-piece suite, 1 sofa and 2 chairs, only 1 set available for the bargain price of $100 cash. This Saturday only. First to accept will be the lucky owner of this amazing deal. Now, already you should have some ideas of things that we're talking about, and you should be able to be taking notes, right, as you read this stuff. On Saturday morning, Rachel saw the advertisement, immediately sent Chris an email accepting Chris's offer. Chris didn't check his email. Leroy was the first person at the shop on Saturday morning and offered to pay $100 by Alipay, but Chris refused and told Leroy he couldn't have the 3-piece suite. Later that morning, Meg asked if Chris would keep the offer open until after lunch so she could go to the bank and get the cash. Chris agreed. Meg left a $10 deposit and Chris wrote her a receipt. Before Meg returned, Dot came into the store and offered $150 cash. Chris agreed to sell it to her. Dot went to the ATM to get the money, and while she was out, Meg returned with the remaining $90, but Chris refused to sell to her. Meg was a real estate agent, and she needed the set for a house that she was showing. Since she was short on time, she went to a nearby furniture shop and paid $300 for a new 3-piece suite. Later that afternoon, Dot called the store to tell Chris that she changed her mind and no longer wants the 3-piece suite. And here are kind of 5 questions that we should look at. So one thing you need to know if you don't is this, and we might have looked at it before, not right of action. What does that mean? So you understand, like, what is the nature of Chris's advertisement? Has Chris entered into a binding contract with Rachel? Right of action, right of action, right of action. So here's like the vocabulary. So what do I mean when I say what is the nature of Chris's advertisement? I mean, is it an offer? That's really what that means. Is it an offer? I hope everybody understands what is a binding contract. By the way, if you guys can turn on your cameras, I would appreciate that. So what's a binding contract? Anybody?
Offer, acceptance, deal. In very simple words.
Offer, acceptance, consideration, intention, certainty.
Okay.
Not just offer acceptance. If I say, do you want to buy my car? And you say yes, we don't have a binding contract. We haven't discussed consideration. We don't know if you're just kidding. We don't have any certainty of how you're going to pay, or, I mean, there's a lot of details we don't know. So binding contract means, is there all 5 things: offer, intention, consideration, offer, acceptance, consideration, intention, certainty. So the nature of Chris's advertisement, that means, is the advertisement an offer? Or if it's not an offer, what could it be? What could it be if it's not an offer, Junpyo?
If it's not an offer,
Too long. Jody, what could it be if it's not an offer?
voidable
Sorry?
contract.
Sorry?
Voidable contract.
Invitation to treat.
Oh.
All advertisements are either offers or invitations to treat. And then right of action. Right of action means, can you sue someone? If I have a right of action against you, it means I can sue you. So another way to say this would be a legal right. Does Leroy have the legal reason or legal right to sue Chris? Does Meg have a legal reason to sue Chris? Does Chris have a legal reason to sue Dot? So let's go back and talk about these. So the first slide, Chris is running this small local business. He places an advertisement. So we know there's some sort of advertisement on a local website. Now here we have the language. And then the question here, anytime you see an advertisement, is really like, what is this? You know, is this an offer? So of course you need to know all of these things about offer. So let's go forward and talk about that. So what is an offer? Well, you need to know, I expect you to know the definition, right? An offer is a proposal to make a contract. That's an offer. I definitely expect you to know the test. And I expect you to know, I don't really care so much that you know the name, although this is an open book test, you really should. I mean, if you don't know the name, it's like, why, if this is an open book test? But you definitely need to know that it's subjective. And like, what does this mean? You know, so the test for an offer, I mean, can you explain that to me? Isaac, can you explain this to me without just reading it? Isaac, you there? No? How about Harry, you there?
Yeah. Basically just would a normal person, like an average person with like using rational logic, would they believe that the offer has been made?
What does that mean? I mean, okay, you explained reasonable person, but you just used these words. Believe that an offer has been made.
Hmm.
Can anybody kind of explain what you think that means? Jody, what do you think that means?
If
You can answer. Like the reasonable person, so the judge will say like, if the offer already is given to the people who receive it.
Okay, I mean, you're trying, that's good.
if the average, any person is the same circumstances will take this offer as a deal. For example, you have to be clear, there is something in exchange, and there is a place.
Okay, I mean, that's good too. You're trying, you know, a lot of the point of this test is that you explain to me what the law says first, and then you really do your best. Who's chatting with me? Okay. Yes, I did get your WeChat. Thank you for reminding me. So I want you to explain the law first, but this is an open book test. So just writing down my definition, it doesn't tell me that you get it. And I will give you more points if you show me that you are trying to explain it in your own world, in your own words. Explain it like you would to a kid. That's what I want. I don't want you to speak in big language to explain it to a PhD or to a lawyer. I want you to explain it to a kid or to somebody who, somebody in this story. Like, they're not stupid people. The guy who runs this store, Chris, he's not stupid, but he's not legally trained. So, I might say something like, would an average person believe that if you say yes, then you have like a legal deal that can't be broken? And if somebody breaks this deal, then they're going to get punished. I think the average person would understand what I'm saying. A legal deal, something that the courts will protect. But these are the kind of words I like: legal, deal, court, protect. I'm not looking for big words. I'm looking for clear explanations. But definitely you need to know the definition, you need to know the test, and you need to know this clear, definite, and precise rule. And then we have some other information about offers. Things like, anything else? Oh, then we have like smokeball is a famous case you should probably know. Smokeball is the idea of a unilateral offer, an offer that is accepted by doing an action, not just saying yes, but doing it, like painting a house or fixing a toilet or something like that. Or in this case, taking a medicine. Fisher v. Bell is the famous case about an invitation to treat, where a store had knives in the window and there was a law that said you can't sell knives. And the store said, we're not selling knives. They're just in the window. It's not an offer. And then what is the definition of an invitation to treat? It's an offer to make an offer. And some examples of invitations to treat. But this is when you have an advertisement, but it's not an actual offer. Then, was Chris's ad an offer? So, first I want you to tell me the law and go through it and explain the law, attach any cases, whatever. Then apply it to our story. So Chris's advertisement said, available for the bargain price of $100 cash for this Saturday only. First to accept will be the lucky owner. Junpyo, do you agree with me that this is an offer? And why?
I think it's an offer because a reasonable person will think that he wants to exchange something with me.
What makes this a good offer? Can anybody tell me? Yeah, Florian?
So there is a time, there is a place, and also, yes?
Sure. So we have the time, Saturday. We have the place, which is the store.
And the nature of the content, the good in exchange of the money.
Okay, we know what you're buying. We know the amount of money, and we know how to pay, cash. And we know who can buy it, the first to accept. This is why it is clear and definite and precise, because we have all of this information in the offer. Now, on Saturday morning, Rachel saw the advertisement and immediately accepted and sent an email accepting Chris's offer. However, Chris was running late, so he didn't check his email. What are we talking about here? Can anybody tell me some of the rules that we're talking about?
Is about the offer, if it's unilateral or bilateral, if you can accept just by an action, or you have to actually send the letter and say, I accept I agree, and then you
Okay.
buy the contract.
But is there any question about that? How can someone accept Chris's offer?
Yeah, so
By giving him the money.
Right? He was very clear. $100 cash, Saturday, come first. I mean, I think this is pretty clear. So what's the problem here with Rachel?
By email. She did it online. This is the issue.
Okay, but you're not telling me the law. I mean, I agree, you're right, that's the issue. But that's applying the law to the facts. You got to tell me the law first. What are we talking about with contracts here?
Is this about like the receipt theory?
That would definitely be something to discuss, the receipt theory. And if you're going to discuss the receipt theory, you also need to discuss the postal rule. You know, what are we talking about? Offer, acceptance, consideration, intention, or certainty?
We're talking about acceptance.
Yeah, right? Rachel tried to accept the offer. So we're talking about acceptance here. So I'm going to expect you to be able to tell me the definition of acceptance, the test for acceptance, and then the mirror rule and the postal rule and receipt theory are probably the three things I think are relevant here. So what is the definition of acceptance? I have it here. Contracts. What's the definition of acceptance? Can someone tell me?
bias is the bias demonstration of agreement.
Good. And what's the test?
Fly on the wall.
Good. Is that
It's
subject?
objective test.
Good. The
Objective.
fly on the wall objective test. Good. And then, of course, you'll need to be able to explain what that is. Like, I'll give you 1 point for knowing that. Because if you didn't come to the test with, I mean, with notes and PPTs, then come on, you're not ready to pass this class. So I 100% expect you would know all the tests here because this is an open book test. I mean, how hard is that? Just bring your notes with you. But if you say it's the fly on the wall objective test, I'll give you 1 point. But if you can explain what that means, that's where you get points. You know, with an open book test, if you just write down the things that are in your notes, I'll pass you. You know, you'll get a 60 or a 65. But if you want a good grade, you need to explain what these things mean. What is the fly on the wall test? What does it mean that it's objective? Jordan, can you explain that? No, no, you can't. No,
The fly on the wall.
Yeah, I want Jordan to explain it to me.
No, sir.
Okay, Tiffany, can you explain it to me?
I guess. Well, yeah, it's simply that the offeree and the offerer both have expressed clearly that what they have agreed on in the offer and that there's no longer negotiation implied. And
Okay.
usually it has to do with the mirror rule because both have to have the contents of the agreement match to each other. There are no major changes, and it's all expressed without any room for confusion.
Okay, I mean, you're kind of jumping around here. You're, you know, you have some ideas that are correct. It's a little bit confused. you know, when I'm talking about what is an acceptance, it is, you know, we have the definition, we got that from Nicola. It's an objective test, it's the fly on the wall test. What that means is, so you said the offeree and the offerer, but acceptance really is about the offeree. The offer, that's about the offerer. So if I make you an offer, I've said before, I'm the master of the offer. If I make you an offer, like you know, Chris says, here is my offer, world. You come to my store with $100 cash, you can buy this thing. That's my offer. Now, Chris could have said anything he wanted. He could have said, you have to wear yellow. He could have said, you have to pay with Alipay. He could have said, you have to come at midnight. He could have made any offer he wanted. The acceptance isn't really about Chris. You know, Chris made the offer. Now that's done. The acceptance is about the customer. And the question is, what did the customer do or say? That's the key idea. What objective means is, what did the buyer or the customer do or say? Jordan, you might want to write down those two words, do or say. What did the customer do or say? Not what did the customer feel. Feelings don't matter, not to the fly on the wall. The fly on the wall can't tell what you're feeling. And so if someone is being sarcastic or someone is just kidding, it doesn't matter. Because the test for acceptance is not what did you feel or what did you think. The test is what did you do and say. So if someone takes out money or shakes hands or says, you know, yes, or, you know, what did you do? What did you say? Then there is an acceptance. Now, of course, we need to know the mirror rule. And the mirror rule just says there has to be a mirror between the offer and the acceptance. They have to be exactly the same. Nothing can change. If the offer was pay in cash, the acceptance has to be cash. If the offer was pay by check, the acceptance has to be check. If the offer said come at midnight, you have to come at midnight. You can't change anything. If the offer said buy one, you can only buy one. You can't change the quantity, the quality, the time, the price, nothing. That's the mirror rule.
I have a question, David. So
Yeah.
in that example, that question, although she sent email to try to show her acceptance, it doesn't count because she would go to the store and buy give cash. So if we don't say anything about the postal rule, is that okay, or should we say something about it because it's related to acceptance?
You should say something about it because it's related to acceptance.
Okay, so basically, I think you did it before. We try to cover as much as possible of the subject. So if we are talking about offer, offer, acceptance, everything that we have, and then we.
Well, let me just say everything that's relevant.
Yeah, but in that case,
you do not have to tell me everything that you have. So, for example, for requirements of acceptance, you know, the buyer may accept an offer at any time until. That might be relevant. So maybe you would say this, you know, but acceptance by silence, that's not really relevant in our story. You don't need it.
Okay.
I'm not going to take away points. Now, if you have enough time to add something like this, I will give another point because it shows your understanding. But a lot of students just think like what you said, the more the better, and they will just copy and paste the whole PPT. To me, that's like a D. That's like a 60. I mean, I know you can copy and paste. What does that show me? It doesn't show me you understood the point of the question. Now, I'll definitely require the definition and the test. That's required for each one. But should you discuss the postal rule? No, for acceptance, you're almost always going to have to discuss the mirror rule. That's just the most important one. What about the silence rule? Maybe. Like if you did not discuss Battle of the Forms, so what? This question has nothing to do with Battle of the Forms. And if you discuss this, but don't give me good explanations, then what I think is maybe you didn't understand the question. And you just saw the word acceptance and copied and pasted everything about acceptance. So don't tell me everything, just tell me the things that are relevant. Okay, so going back. So we had Rachel, and she sent an offer by email. So the question that we actually had at the beginning of this test, has Chris entered into a binding contract with Rachel? No.
No.
No, there's no contract with Rachel. And the reason is the only way to accept this offer was bring $100 cash on Saturday. That's it. It doesn't matter how you do it. If you don't do that, you didn't accept it, because that's the mirror rule. So simple answer is no, they don't have. Does it matter that Chris didn't check his email? No, doesn't matter. Leroy is next. So Leroy is the first person on Saturday morning. He offers to pay $100 by Alipay. Chris refuses. Right? And the question is, does Leroy have a reason to sue Chris?
No.
Why not?
Because he said in the offer, cash. I'm not saying Alipay is not cash, but is a way to pay like PayPal. Is like
Doesn't
online.
matter. He said cash. You know, he said cash. Alipay is not cash.
Yeah.
So this is the same as the last one. It's acceptance fails because it breaks the mirror rule. Here, there's no postal rule. It's just the mirror rule. Later that morning.
Oh, sorry. So basically, that question is kind of the same of question 2.
Mm-hmm.
So we do not need to explain about acceptance and so on. We can just say like, according to the previous question, this is acceptance, blah, 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 and then apply the law in the case. Right?
Absolutely. Yep. You just say this is the same as the previous question. Next, Meg asked if Chris would keep the offer open until after lunch so she could go to the bank to get the cash. Chris agreed. Meg left a $10 deposit as a gesture of intent to buy, and Chris wrote her a receipt. What are we talking about here?
Legal relationship.
But everything in this class is about legal relationships. What part of contracts?
Consideration.
Yes, consideration. We're talking about what did the parties give to each other. So, okay, now we're talking about consideration. Let's take a look at this. So did Chris make an offer to Meg? Okay, we have that. Now, did Meg accept the offer? That's kind of the first question.
She did agree. She did.
She did not. She did not agree.
She says she don't have the money, like the full of amount.
Well, was his offer, anybody who comes on Saturday and says they don't have the full amount of money can then go to a bank and I'll keep it open? Was that his offer?
But she
No,
said
he wasn't.
$10 deposit.
Okay, but that's different. Chris made an offer. You come into my store with $100 cash, I'll give it to you. That was his offer. Did Meg come into his store with $100 cash? No. So she did not accept his offer. Remember, offers can't be changed. The mirror rule, offers and acceptance have to match. So what did Meg do here?
Counter offer.
Correct. She made a counter offer. So Meg made a new offer to Chris. And what was Meg's offer?
A down payment.
Sure. Meg's offer is, I will give you $10 deposit now. And then you, for $10, you keep the offer open until after lunch, and I'll come back with the rest of the money. We know that Chris accepted Meg's offer because he wrote her a receipt. He took the money and wrote her a receipt. So now we have an offer by Meg, an acceptance by Chris, and new consideration. So what did they exchange? What did they give each other? Meg gave him $10. That is valuable. And Chris gave her a promise to keep the offer open until lunch. And that promise is valuable too. So what are we talking about here with this idea of valuable and not valuable? You're going to have to explain to me. Where did I put it here? Consideration. So always definition and test. I expect for consideration, you don't have to tell me this sentence, but you're going to have to explain to me that consideration must be valuable. That's a really important idea. So that what Meg gave Chris is valuable, that $10. And what Chris gave Meg is valuable, that promise to keep it open until lunch. So, anything else about Meg and Chris? Well, there is, in fact, but not necessarily yet. Let me.
David, I have a note here, but I'm quite confused. So it's saying part payment is not good consideration.
That is correct. Part payment is not good consideration. But this is not part payment.
But
This is a down payment. Is different, I think so, from part payment.
So it is different. Can you tell us how part payment is different from a down payment?
I will say the time between. I think so.
Well, what Meg did, the down payment or the deposit, that says, well, let me explain. That says, I'm going to give you some money now, and then I'll pay the rest in the future. Does Meg, before any of this happened, does Meg already owe money to Chris?
Before which date? Before she give 10%?
Before she ever saw the advertisement.
No, she doesn't.
Never.
No. So there's no part payment. Part payment is only when you owe money to someone. So what if Meg and Chris were friends for years? And a year ago, Meg borrowed money from Chris. A year ago, she borrowed $1,000 from Chris. Now, if Meg owes Chris $1,000, and then she sees Chris's advertisement, and she goes into the store on Saturday and says, Chris, here's $100. Give me the sofa and the chairs, and now I only owe you $900. Chris would say, no, no, no. You want the sofa and the chairs, that costs $100. You owe me $1,000. These are separate debts. You can't give me 100 and I give you something and now you don't owe me. I mean, that doesn't make sense. If you owe me $1,000, you want to buy this thing, that's 1,000 plus 100, not 1,000 minus 100.
What about if it's the opposite? Like
Explain.
Chris owes money to the lady.
Oh, sure. If Chris owes her money, $1,000, and Chris says, listen, I can give you 900 and the sofa and chairs. And she says, okay, no problem. Because that is changing what.
But what about she came to the store and say, this, I want this sofa because you owe me 100. And he said, no, because the offer is 100 cash.
Of course, absolutely, he can do that. He owes her $1,000. That's what he owes her. He doesn't owe her a sofa. He doesn't owe her this sofa. You know, he owes her $1,000. Now, if she wants to change, what if Meg said, hey, Chris, I love this sofa. You owe me $1,000. You know what? Give me 500 and this sofa. And what if Chris is very honest and he says, well, but look, this sofa is not worth that much. It's only worth 100. And she says, I don't care. I love it. Give me this sofa and 500. Okay, then the sofa and 500 and the debt is over. Because the consideration has changed. Right now, he owes her $1,000.
Good.
Part
Thank
payment is only when you owe money to someone. You can't go in, give them some of the money and say, now you owe me something. No, they don't. You have to pay your debt.
Understood.
Okay. So, you know, do you need to discuss that in the test? Well, if you do, I'll give you extra points. It's not really part of the question. You know, forbearance. You have to know forbearance. There's a very good chance I'll ask about it. This particular question isn't about it. So do you need to discuss it? No, but it would be good to. Pre-existing duty rule, moral obligation. It's all stuff that we learned in consideration, but you need to make the decision about what you talk about. But understand, as I said before, if you finish this test in an hour, you're missing something. You should need at least 2 hours. So some students will think, oh, this question is just about the mirror rule. I'm just going to write mirror rule equals this. Offer must match acceptance. The end. No, that's not a good answer. You need to take the time and explain yourself. You know, promissory estoppel, that's not part of this question. There's no need to talk about that, but I'll give you more points if you do. There's a good chance that will come up somewhere. Okay, back to the question. We did Leroy, Meg, so we know they have a contract. Now, before Meg returns, Dot came into the store and offered 150 cash, and Chris agreed to sell it to her. And Dot goes out to the ATM to get the money. So let's talk about this. What's going on here? Well, we have an offer. Did Dot accept Chris's offer?
I think yes, but there is, because in Chris offer, they say bargain. So maybe you can raise the price.
Jordan, what was Chris's offer? You're muted.
100.
That was Chris's offer, right?
Yes.
That's what he said.
Yes.
Did Dot accept his offer?
Yeah, he said no.
Did Dot give him $100?
No.
No, she did not accept.
So what means
Done.
the bargain? What part does it mean? Bargain prices, like you can bargain, right?
No, this means the low price.
Is only when you want to change the price to lower, not upper. Okay.
Your bargain has two meanings. Bargain, you're thinking it means negotiate, like let's bargain. That's not really what it means in this way in English. The bargain price just means the good price.
Sorry.
It's just a synonym for good. So Dot offered 150 cash. She made a new offer. Did Chris accept her offer?
Yes.
Yes. Chris accepted the offer. They exchanged consideration, right? Well, she goes out to get the money, but the consideration will be Dot gives him money and he gives her the sofa. So, okay, that's good consideration. Whose microphone is on? Okay. So they exchange consideration, intention. I mean, you should explain intention and certainty, but it seems okay. Now, she goes out to get the money, and when she's out, Meg returns with that remaining $90, and Chris refuses to sell it to her. What's happening here?
I don't know like the name of the rule, but it's the same that I think like postal rules. So people who send or who get the thing first or send the money.
What does this have to do with postal rule? Meg walks into the store with $90 in cash. Meg said, I'm going to give you $10 now, and I'll come back a little later with the rest of the money, right? And then she came back. She came back with the cash. There's no postal rule.
At which hour she came back? Because the time was important.
Okay, I don't know. I didn't write it here, but let's say it's fine. She came back before lunch.
Then she has the right to have it.
Does she? What did Chris do? Harry, what did Chris do?
He already sold it.
Yeah, speaking law, what did he do?
So he accepted a counter offer before she returned.
So what did he do to Meg's? Did he have a contract with Meg?
He had a contract with Meg, and
so what did he do?
Breach.
Yes.
He broke the contract.
Yeah.
That's what I'm looking for. He broke the contract. He breached the contract. That's fine. But that's what he did. He broke the contract with Meg. Is that okay? Can he? Sure. Except there is a punishment if you break a contract. So he broke the contract. Okay, you can always break a contract, but there might be a punishment. So first of all, he's going to have to give her back the $10, right? Of course. Now, what happened? So Meg was a real estate agent, and she needed that for a house she was showing. She was short on time, so she went to a nearby furniture shop and paid $300. So she might sue him, right? Does Meg have a right of action against Chris? Can Meg sue Chris? Jody, you say yes? Why?
Yes, because he broke the contract.
Okay, so how can she sue him?
Before she already paid for the down payment.
Okay, well, tell me a little bit about the court case. What's she gonna get?
The money, she has to sue for the remedies.
Okay, the remedies. Thank you. What kind of remedies?
Financial.
Well, okay, of course they're financial remedies, but okay, I mean, maybe you mean not equitable, but sure.
Injunction.
Injunction? I don't think so. But I mean, Tiffany, keep going. The remedies. Tell me about the remedies.
Maybe because Meg didn't have the readily available option to buy anywhere else. So
Okay,
she can only
kind of.
buy at higher priced.
Okay, but you're jumping forwards. You're analyzing the situation before you've told me the law.
Okay.
So I want to know the law first. You're correct that she will get remedies. Now, what I want to know is what kind of remedies, not her personal situation, but what kind of remedies in law are available. So, for example, in remedies, there's two kinds of things you can get for breaking a contract. One thing is called damages. And there's two kinds of damages, direct and indirect. What's the difference?
So the direct, you can see with the receipt, but indirect, you just about the pain and suffering.
Okay, so let's talk now, Tiffany. Will Meg get direct damages and will Meg get indirect damages?
Probably mostly direct. I don't think this is indirect, but it depends on the person. Because no, there's indirect too. Never mind.
Okay, so what
Because
direct damages will she get?
it's the difference between Chris's offer, the money $100, and then the 300, which is 300 minus 100 is 200.
Correct. So that's what
extra money she paid.
Yeah, I agree. So I think that's what she'll get. And now this case doesn't really have expectation versus reliance. This is an important thing to know because there's a very good chance I'll ask about this. So expectation versus reliance, this is only for a case where someone is selling things. Meg is not selling the sofa. You know, if Meg was selling this to another store, let's say Meg was going to buy it for $100 and she was going to sell it for $1,000. Now, Chris, he doesn't know that she's going to resell it. But Meg is a fashion designer, for example. What if Meg is a fashion designer and she's going to sell it to a company for $1,000? Now, Chris would say, okay, you expected to pay $100, but actually you paid $300. So I'll give you $200. That would be the reliance loss. That puts you back in the position you were in before the contract. So you expected to spend 100, you spent 300. The difference is $200, that's what you get. But Meg might say, no. I expected to spend 100 and make 1,000. The difference should be $900. That would be her expectation. She expected to make. So now in this case, Meg didn't expect to make any money. She was buying it to use it. So there's nothing here about expectation versus reliance. Is that clear? Because that's pretty important to me. Jordan, can you explain this to me?
About the expectation, yeah, when you expect to buy something and you couldn't get it, right? For example, she wants to buy and he sells for somebody else. That means she was rely on this sofa and he sell it for somebody else.
So she expected to make a profit.
Yeah.
That's the key. Okay, good. That's the key idea. Expectation is only when someone's going to make a profit. And Meg is not going to make a profit here, so this is not relevant. What is relevant, though, if I was Chris's lawyer, what would I say? I would say that she broke the requirement to mitigate. Can someone tell me how Meg maybe broke this requirement?
Because of the only down payment and not the full cash?
No, that's not it.
Because of intention, like she deliberate. how do you say? She premeditates her action.
Premeditate.
It's like she
That's
she
the
did
word
it
for
on,
murder.
yeah, on purpose.
Did it on purpose. Well, okay, maybe. I think I see your argument. But Jordan, what were you going to say?
He wants to say deliberately, right?
Okay, yeah. I mean, yeah. I think I see your point. But what is this requirement? This is a requirement that people have to do something. What do they have to do?
Is it because
Can
like
I say like, go Harry, go Harry.
Yeah, I was gonna say like she spent 200 on a new sofa, or 250.
Three.
Could she maybe have found 300? Sorry, maybe she could have found like a cheaper option.
That's correct. That's the requirement. The requirement is you have to look for a cheaper option. Now, if it's like Florian said, and it was deliberate or premeditated, what if Meg was really angry and she went to the most expensive furniture store in the whole city and she bought furniture and she bought a sofa that cost $10,000? That would be deliberate, right? And then she calls Chris and says, hey, you broke the contract, so now you owe me $9,900. That would be very deliberate. Yeah, Jordan?
But she cannot use, how to say, the law to punish the other like that, right?
Correct. She can't use the law. Now, in this case, she bought something for $300 and she was short on time. So probably she would lose this argument. You know, Chris would say, I think you deliberately bought an expensive thing. And probably he would lose because she would say, no, I didn't. I was short on time and I bought something that was only $200 more. If I bought something that was $10,000 more, okay, but I didn't. I just bought something a little more expensive. So probably Chris, so that's the irony here, is that Chris accepted Dot's offer. Now, why did Chris accept? Oh no, what did I do? Why did Chris accept Dot's offer? She offered more money, right? Dot offered 150. But actually, because Chris is breaking the contract, he's going to end up losing money now because he's probably going to have to pay $200 to Meg. Now, what about this? Dot called the store to tell Chris she changed her mind and she no longer wants the three-piece suite, the sofa and chairs. Can Chris sue Dot? What do you think? Carlotta, you there? No? Tiffany, what do you think?
I think it's actually not possible.
Okay, but you're about to tell me common sense. I want you to tell me law.
Okay, I take that back. I think the consideration is that is there. So, but the fact is, Chris actually doesn't have. I don't know. I don't think he has any proof that he could sue her. That's it.
Well, let's
Even if
start
she
at the
is
beginning.
losing-
We always start at the beginning. Offer,
Okay.
acceptance, consideration, intention, certainty. Let's start with offer. What's the offer here?
The 150.
Okay.
150.
Dot offered Chris $150. That's the offer. Now, do we think this is a good offer? You know, you have to then look at the test. Would a reasonable person think that if I say yes, this woman Dot will give me $150? No, okay, maybe yes. Did Chris accept the offer?
Yes.
Yeah, I mean, we just know it because the question says. So, you know, maybe he shook hands, we don't know, but the question says that he did. So we have offer, we have acceptance. Is the consideration okay? $150, that's valuable. The sofa and chairs, that's valuable. Consideration is okay. Intention, were either of them kidding? Were they drunk? Were they making a mistake? That, you know, she said 150, but she didn't mean dollars, she meant RMB. Or no, it sounds like they had clear intention. All the terms are certain. They know how much money, they know which sofa and which chairs. Offer, acceptance, consideration, intention, certainty. I think this is a valid contract. Now, Tiffany makes a good point that maybe there's no evidence, but that's a separate issue after we decided, is there a contract? So the question, is there a contract, means, is there offer, acceptance, consideration, intention, and certainty? Here, it looks like there is. So they have a contract. She agreed to buy it for $150. Now, she goes out to get the money. And then she calls him and says, I changed my mind. Can she change her mind?
You can always breach a contract. You are always
Sure.
free. You can always breach a contract, but
Okay.
there is some consequences.
So what are the consequences?
Get sued.
He could sue her for how much?
What she promised to him, but also if someone after her promised more, because of her, he turned down the other potential gains, so he can
Okay.
have some.
I think I hear an echo. When your microphone is on. Now, echo? Oh, now it's gone. Okay. So yes, I agree. He could get 150 cash. Now, if somebody else came after and offered him more money, maybe he could get the future opportunities. That would be an indirect damage. Now, I did write something on the slides that actually is wrong, so I should change it. What I had originally written was Chris versus Dot. Okay. So I said Chris has no right of action because Chris cannot make a new contract for the same sofa because it's already promised to someone else, but that is not correct. That's not correct.
Also, so I have a question.
Yeah.
You know the 5 conditions, if the majority, for example, 3 of those 5 conditions are aligned, can we still say they have a contract because there is only 3, like the absolute majority?
No. Offer,
Okay.
acceptance, consideration, intention, certainty, all of them.
Okay.
So the reason I had said this before is I said, had he sold, here it's Dot, the 3-piece immediately, but he did. He didn't give it to her and she didn't give him the money, but he did sell her this immediately. She offered the money, they shook hands, they're fine. Now, what if he already sold it to Meg? Let me change the example. What if Meg gave him $100 and he said, okay, Meg, it's yours. And she said, okay, I'm gonna come with a truck this afternoon to pick it up. And he said, no problem, I'm gonna put a tag on it that says sold. So he puts a tag on it, or he forgets to put a tag on it, but it's sold to Meg. Now, can Chris sell it to Dot? Now he could not, because Chris didn't own it anymore. It was Meg's. She just hadn't picked it up yet. But in this case, he'd be breaking a contract. I mean, I guess he could. They say possession is 9/10 of the law.
2 weeks ago, the same situation happened, but it was for a refund, and you said if he can sell it after and give back to the person the refund. So basically, maybe he can sell it and give her.
I mean, that's it. He could. You're right. He could, even
money
if
back.
Meg paid the $100 and said, "I'm going to get it later with a truck," he could still sell it to Dot. And then Meg comes later and he says, "I'm so sorry. I sold it. Here's your money back." And Meg might say, "Well, I'm going to sue you because, I rented this truck, or now I didn't buy this other thing, or, you wasted my time," or whatever. And she could sue him. But hey, if it's worth his time, what if Dot represents a big furniture store? What if she represents IKEA or something, and he really thinks it's a good opportunity to sell it to Dot? He could.
But as the furniture now belongs to Meg, is it not a kind of felony? Like you selling
No.
something that's not yours?
I see your point. I see your point, and it's true. He's selling something that technically he has already sold, and that's why, it should be that he can't sell it because it's not his. Like, in terms of a legal fiction, that thing isn't in his store anymore. It doesn't exist to him. It belongs to someone else. She just hasn't picked it up yet. So in that sense, he shouldn't be able to, but the law can't deny reality, which is it is there. And he could sell it to Dot. So you're right in the sense that he shouldn't be able to, but the fact is, because Meg didn't pick it up yet, there is a risk that he could sell it to someone else, and he did, and now Meg is going to sue him.
So there is a contract.
With Meg?
With Dot?
Right. He broke his contract with Meg and made a new contract with Dot. And now when Dot doesn't buy it, he can sue her. The problem for him would be that the question did not say, like, he agreed to sell it to her. We don't know if they wrote up a receipt. And without a receipt, we get into the problem you said about having no evidence.
Sir, when Meg sue Chris, who will win the case?
In this case, Chris will win, but he will win I would say he would win because they did have a contract, but he might not be able to prove it. And if he can't prove it, then, he would lose. I don't really expect you to know anything about evidence. We haven't talked really about evidence in this class. We don't really get into evidentiary law at all. So if you said Chris wins, I'd say you're right. If you said Chris wins, but he has no evidence, I would say you're right +1. I'll just give you extra points for knowing anything about evidence, because that's true, and you're right. But we haven't talked about it in this class. So my questions to you are kind of like, in a perfect world, what would happen?
And also, we don't have to discuss who will win or who will lose, right? Because we just preparing the arguments to go to the court.
Well,
But
you'd be advising, does Chris have a way to sue Dot? So you're right. You don't need to say who would win. But if you said, like, does Meg have a right to sue Chris? Yes, she's going to sue him, and she's going to ask for damages, and she's going to ask for reliance losses, not expectation. And Chris might argue that she broke her requirement to mitigate. Yeah, you don't have to say who would win. You can if you want, but yeah, it's not required. I'm not asking you that specifically. So, okay, that's contracts. Take a look at that on your own. There's 2 questions I gave you, contracts 1 and 2. If you guys want more or you want another practice test, tell me. I'll put another practice test on. That's fine with me also. let's go on to, let's do one more and then we'll take a break. Because I have a lot of practice tests or practice questions. Let's do company law. I have 2 practice questions. Which one did I put online?
I think you put both.
Company law 1 and 2. Okay.
Company
Then-
law questions 1 and 2, yes.
Yeah, let's do question 2. See what that is. Unless, do you guys want to take a break now or do you want to do one more?
Can do one more.
Okay. I chose company law because that's not too long. Okay, Michael exports pet toys from Boston to Shanghai. He ships the toys to a Chinese company called Dogs and Gods Incorporated, D&G. The Chinese company then distributes the pet toys to stores around Shanghai. Michael has been shipping goods to this company for 2 years, and the deal is that D&G will pay the shipping costs. For the past 6 months, D&G has refused to pay the shipping costs. The total amount owed to Michael is $50,000. Recently, Michael tried to sue them and found out that D&G is bankrupt. The owner of D&G, John, operates his distribution business from his home. He does not have a separate office or telephone number. He uses his personal bank account for the business funds. Although D&G invested very little money in their company, John himself is quite wealthy. Michael would like to sue John personally. John argues that he can't be sued personally because his company, D&G, owes the money, not him. Okay, so 2 questions. Number 1, what does it mean to be incorporated? And number 2, can he pierce the corporate veil? So what does it mean for a company to be incorporated? How are we going to answer this question? Who can get us started? Junpyo, you want to get us started?
Okay. Incorporated means that you don't have to pay for the loss if the company is sued by someone. So it's like a different person.
Okay.
Company and you.
Okay, the company and you are different people. That idea that you don't have to pay for the loss if the company is sued, what court case does that come from? Anybody?
The limited, how to say?
The name, I want the name of the court case.
Limited liability company.
No, that's not a court case. A court case is A versus B. What's the court case?
I try to remember.
You shouldn't have to remember. It's an open book test. Don't remember, prepare your notes. So, Florian, what is the name of the court case?
Solomon versus Solomon.
Thank you. That is the name of the court case. And this court case gives us 2 rules. I expect you to know both of these rules. Number 1, the company is responsible for its own debts. Number 2, the company is a separate legal entity, just what Junpyo just said. So it's a separate legal entity and it's responsible for its own debts. Those are the 2 rules that we get from Salomon v. Salomon. So what does it mean that a company is a separate legal entity? What does that mean? Tiffany, can you tell us what that means?
What is a separate legal entity?
Yes.
I don't know. I think it's just not, it's not a natural person. It's exactly what was just stated.
It's
I
not
don't know.
exactly what was just stated, but
Oh,
you're
okay.
right. You're right. It's not a natural person. It's a legal person. Florian, what does it mean that it's a legal person?
So, it's a legal person. So the company has rights and duty and action.
Okay, tell me about some of the rights of the company.
Can sue and can be
It-
sued.
Exactly.
Yep.
Yes.
It can sue and be sued. It can own property
And makes contracts. Yeah.
and make contracts,
All the legal action.
right? So it's not a natural person, but it does have rights. You know, that's kind of what it means. Now, what's the benefit of opening a company, creating a separate legal person?
You are not.
So when people sue, the people only can sue the company, not the person.
What's that called?
Financial liability, legal liability.
Close. Limited liability.
Oh yeah, LLC. So
So you're right, Jody. That's the first big benefit. And that's called limited liability. What's any other big benefits?
of a limited liability.
Yes, of opening a company or incorporating a company.
The company never dies.
Correct. The company never dies. It's a big benefit. Any other benefits?
What do you mean by it never die? What do you mean?
I mean, Apple will never die. Facebook will never die. The owner of Apple can die. The CEO could die. The vice president could die. But Apple can't die. Ever.
Forever?
Forever.
Even if there is zero, like no activity, no nothing, they can still live. Is like shut down.
Well, then they'd be bankrupt.
Oh.
But they're not dead. They can't die.
Okay.
What happens if Apple goes bankrupt?
They just own, I would say trademarks, like the known name and all of the.
Okay. So maybe they sell their factories, they sell all of their stuff, they sell their buildings, and now maybe they just own the intellectual property, so maybe they sell that too. Then they own their name, maybe they sell their name, and now they change their name because they have to be named something. So now they're called like A Incorporated. And A Incorporated is kind of like a vampire. They exist. They have nothing, they have no assets, they don't do business, but they're not dead. There's only one way to end a company. We didn't learn that. It's in corporate law, I would teach that, but it's called winding up. That's how you end a company. You wind it up. That's just what it's called in law. And to wind up a company involves first of all, you need to make sure you've paid the government, your taxes, the utilities, water, gas, electricity. Then you have to pay or going to be sued by your lenders, the people who owed you money. And we talked about this a little bit with fixed assets and floating assets and who you sue. Just very briefly, let me do something that is totally a waste of our time. Let's see.
Is it when the government take your company because you cannot no longer pay, so the government take it by force?
No, the government doesn't have to take the company. So pretty much, if a company is going to close, let's see if there's anything. Well, if a company winds up or is, what just happened? If a company winds up or liquidates, That means they turn all of their assets into liquid. So they sell everything, sell the buildings, sell the factories, sell the furniture, sell the computers, sell everything. And then it's just liquid, it's just cash. Once that is done, they must make payments in these orders. They must pay the costs of winding up. So you want to sell your house or your buildings, you have to pay some real estate companies to help you sell the buildings. You want to sell your computers, you have to pay some company to come in and collect the computers and auction them, or you got to pay those costs. Then you pay fixed charges, which is anybody who lent you money based on a building, preferential debts, floating charges, unsecured creditors, anybody who lent you money, and then any surplus you give to your shareholders. And after that, then you are allowed to close your company. You have to send forms to the government, and the government needs to stamp them and approve, and then your company is dead. But until you do that, companies do not die, ever. So, okay, that's pretty much all the stuff I wanted about question 1, right? Like, what does it mean for a company to be incorporated? I wanted you to explain, this idea of it's a separate legal entity, Salomon v. Salomon. What does it mean to have rights as a company? And then some of the benefits of having a company. Now, task 2, this idea of piercing the corporate veil. So what does that mean and how do you do it? Right? So what does it mean to pierce the corporate veil?
Can you take legal action against him personally?
Who's him?
What's his name? Solomon directly.
Well, I mean, we're not talking about Solomon in this case. Solomon was the first one. We're talking about this guy, what's his name? John. John is the owner of this company. So yeah, can you sue the owner directly? Because we saw in the question that this guy, John, himself is quite wealthy. So even though D&G has very little money, you want to sue John himself, or Michael wants to sue John. So how do you pierce the veil? How do you do this? We know that there are 3 tests, right? Unity, conduct, and cause. And unity is the owner and the business together, or are they separate? Conduct is, did the owner open this business for a wrongful purpose or with dirty hands? And then cause is, did someone get hurt directly because of this business? So in our case, is there unity? In the case of Sealand v. PepperSource, they told us the definition of unity has 4 factors. Did John have good corporate records? Did John mix funds? Did John undercapitalize? And did John treat the assets of another company as his own? These were the 4 sort of definitions of unity, and that comes from the case Sealand. So what do we have here in our facts? Okay, so Michael exports toys from Boston to Shanghai, and he does it with this company, D&G, that John owns. And they've been doing this for about 2 years. And D&G will pay the shipping costs, okay? For the past 6 months, D&G has refused to pay the shipping costs. And they owe Michael money. D&G is bankrupt. And this guy, John, who runs D&G, he runs it from his home. Okay, that's one thing. No separate office, no separate telephone number. He uses his personal bank account for the business funds. So he's mixing the business with his money. So we have some facts here that make it sound like there's unity. Do we have everything? Not really. We don't know if he undercapitalized it. Do you understand what does undercapitalized mean? Yeah, Jordan?
And I think in the beginning, if you see, he has a very good record with the supplier.
Yeah, I mean, they've been working together for 2 years.
Yeah.
And this
And
problem
because-
was only in the past in the past 6 months. So it's hard to say. I mean, it sounds to me like there is unity, but there's not perfect unity. I mean, unity, we said from this case, does John keep good corporate records? We don't know. Maybe. Does John mix funds? Yes, he does. So we know he does this. Is it undercapitalized? Did he not put enough money in D&G? Well, I guess, because there should be enough money to pay the shipping. So maybe he did this.
What does mean undercapitalized? What does that mean?
There's not enough capital in your company.
So it's like your expense are much more than your benefit.
Well, it's not about benefit. Let's say that I open a company to be a wedding planner, for example, and I make a contract with you, Florian, to handle your wedding. And the wedding costs, you know, whatever. Weddings are expensive. Let's say it costs 200,000 RMB, really expensive wedding. And a month before your wedding or a couple of weeks before, I break the contract. And I say, man, I'm sorry, I'm too busy, I can't do it. And you want to sue me. And I say, hey, go ahead, it's a company. You can't sue me, David, you can only sue the company. So you sue the company, David's Wedding Planners. My company has 1,000 RMB in the bank. So I don't care if you sue me. Now, in that case, the court might say, that's not fair. I mean, that's, you know, David took a contract with Florian for 200,000 RMB, knowing that weddings are very expensive, but I didn't have the money to handle anything.
So you mean like the company doesn't have capital money?
Exactly. The company doesn't have enough in the bank to pay its debt.
But do you need it?
In case I get sued, yes.
Oh, really? Okay.
Yeah, you can't open. Now, look, there's some companies you can open with almost nothing. Let's say I want to open a company to teach Chinese, to teach English. And I open a company to teach English. I don't need to have a lot of money in the bank because you're not going to, what are you going to sue me for? You know, this isn't the kind of thing that's a big money thing. If you pay me money and then I break a contract, I just give you the money back. But something like a wedding or shipping, import and export, if there's a mistake or a problem and you get sued, you need to have enough money in the bank to handle that. You can't just open a company with no money. Like Jordan, for example, you have a company that does like bodyguard and protection services, right? I would guess that you probably did not need to put very much money in because it's a personal services contract.
Okay, teacher, what you say is like you advise or is required? Is it
Required. Different kinds of companies have requirements about how much money you need to have in the bank.
okay? And you don't touch it. It's like a kind of deposit just to enable your company to be still open, kind of.
To be protected, yeah. So some businesses, to get a license, you need to have 100,000 RMB in an account that you can't touch for 1 year. Other companies need to have 50,000. Other companies need to have 10,000. Some need to have 5,000. Some need to have nothing. Jordan, what are you going to say?
I said, this is not in China, right? I think maybe in the United States.
No, this is in China too. It depends on the kind of company.
Okay. Because
And
for me,
also one last question, because
yeah, I said Jordan, probably you didn't need to put anything because it's a personal services contract.
Yeah.
This also depends of the how do you say, the amount of people or the size of your company. If, for example, there's 2 people who work in your company,
Doesn't matter. It's not about the size of the company. It's about what your company does, the scope of business.
Okay.
If your company, for example, buys and sells like big medical equipment, like CAT scanners and things like that, you absolutely would need to have 100,000 RMB in the bank minimum. You might need 1 million. I mean, they have different requirements, but there's no way that the government of China would let you open a business to buy and sell $1 million machines with nothing in the bank. No way. They would never give you that. Now, if you want to be a bodyguard, or like I opened a company once in China in order to teach theater. I did not have to put money into the bank to teach theater. Why would you even sue me? If you don't like my classes, just don't take them. I mean, what are you going to sue me for? You know, what, I broke the contract, my theater teaching wasn't good enough? You know, but you didn't need money for that. But a lot of companies you do.
Mental, how do you say?
Yeah, you know, but no, no, I'm not a medical doctor.
Okay.
That's like saying if I teach you English badly, it could hurt your mental state. It's just not true. Yeah, Jordan.
But sir, what if people expected from you good about the theater and then they registered and later they didn't, they were disappointed? Can they sue you?
They can sue my company.
Okay.
But they couldn't sue me.
I think this side of the contract is like insurance, right? So maybe this is related to your insurance. It's like, does your company have an insurance? Something like this, right?
Well, remember though, that the company will look at the totality of the circumstances. So the court is not going to only look at this one factor, but it is relevant. If you put no money into your company and then started doing import and export, did you really expect to be protected? It's just one factor the court's going to look at. You know, how can, like you said with insurance, how can you be running a company if you have nothing in the bank? It's not the only factor, but it's a factor. Just like, why are you mixing the money with your personal money? Or why didn't you keep any records of what you bought and sold? It's not the only factor, but it is a factor. So these are all factors. And it looks like in our story that this guy, John, he mixed money and it looks like he was undercapitalized. We don't know if he did number 4. We don't know if he had many businesses that were all borrowing money from each other. We don't know. But we know there's some sort of unity. However, what was said before, they've been doing business for 2 years. So the second rule, wrongful conduct. Did this guy, John, open the company D&G to commit fraud? No, it doesn't sound like it. I mean, it sounds like they were doing business for 1.5 years already. You know, they've been doing business for 2 years. It sounds like D&G is just a Chinese company. But for the past 6 months, they haven't paid for shipping costs. This is kind of Michael's fault. He shouldn't have let them not pay every month. And what about the last one, cause, proximate cause? Is Michael hurt because of what John's company did? Sure. John's company didn't pay their debt, so yeah, he's hurt. You know, so we know this case is actually very similar in our case. John incorporated the company. He had no separate bank account, telephone number, office. The company was undercapitalized. It was run out of his apartment. There's probably unity. Michael was directly injured because, you know, there is proximate cause. However, the problem is, like we said, the second part of the test, wrongful conduct. This company wasn't open for a bad reason. And that is very much the same case as this case is very similar to the case of Sealand v. Peppersource. And in that case, the court did not pierce the corporate veil. So they probably won't in this case also. Any question on that? Tiffany?
So you say that is liable, personally liable, right?
No, I don't think so. I think the court will not pierce the corporate veil.
Mm. Also, I have a question when you say he ran his business from his house. So when you open a LLC, like limited company, you have to have a different bank account, different mailbox, kind of, and physical address too.
No, you don't have to. You don't have to. All of these things are just indications of, are you separate? Now, most companies, like if you open a company in China and you use an agent, they will let you use their office as your address, or they will have a separate PO box. You could use your home address, and that's okay. You can do that. You definitely should have a separate bank account. I mean, 100%. Separate telephone number? No, you don't need that. These are just indications. Now, if you didn't do any of it, no separate bank account, no separate phone number, no separate office, didn't keep records, put no money into your company, mix the money with your money, I mean, just every single thing, well, then clearly that's bad. You have unity. If you just didn't have a separate office, that's not bad. It's really about just all of the things together, the totality. Okay, let's take a break. We'll come back and we'll do the other two subjects. We are recording again. Okay, so we did contracts law and company law. Let's go into, let's do agency. Okay, agency law. Peter has an import and export trading company. Recently, Peter purchased some top quality raw silk from a factory in China that he wanted to sell to companies in America. He told his friend James that if anyone could help sell the silk, he would give them 10% of the profit. Based on this, James contacted some companies he knew in America and found buyers for the silk. Peter was very happy about this. Peter contacted these customers and made the deals. Peter asked James if James would like to continue being his agent, and they signed an agency agreement. James asked about his 10% commission from the recent sales. Peter says those sales happened before James was his agent, so he was not entitled to that money. Let's take a look at that first. There's a little more, but so Peter has this import and export trading company, and Peter bought silk from a factory in China, and he wanted to sell it in America. And he told his friend James, if anyone can help sell the silk, he would give them 10% of the profits. Any thoughts so far on agency law?
He mandate his friend as an agent.
So maybe, did James make him an agent?
Not by contract, but by action.
Well, I need legal terms. I mean, that sounds a little common sense. We have legal terms for all of this stuff. How do you create an agency relationship? Yeah, Jordan?
I think at that time he's his agent
Why?
because he told him to find for him, how to say, the buyers or so. And that time
Okay.
he can be the agent, yeah. The just for this time.
But he told his friend if anyone could help sell the silk, he would give them 10%. He didn't say, you, James, help me. He just said, if anybody could help me, I'd give them 10%.
But that anyone that who did that can be the agent.
Maybe so. Could be. You know, so definitely what I want is, I want to know the law. How are agency relationships created? So we already have, you know, we have some information that you need to know. So first thing we need to know is there an agency relationship? And to know that, we need to understand that there are 5 things needed to create an agency relationship. Now, right now, maybe this guy, what's his name? Peter. Peter would be the principal and James would be the agent. Did they mutually agree to have this? Well, no. Is James under Peter's control? Well, no. Do they have a relationship of high trust? Well, no, not yet. So that doesn't look like they're an agent, but we understand that agency can be created in 5 ways. And we need to understand these 5 ways. I mean, this stuff is on the test. So we need to understand. Now you say that maybe, and I agree with you, that maybe Peter actually did make his friend James into an agent. If that's true, and Peter made James into an agent, how did he do it? Was it express? Express is where you tell someone, I want you to be my agent. Did he do that?
No.
No. What about implied?
Yes.
So what does implied mean?
Like he doesn't make like a contract with on the paper, but just like saying, right?
Okay, and yes, that's what Isaac said too. So you were both correct. It is implied. Implied is that it's clear, but he never said, I want you to be my agent. Here's the contract. We should understand what is apparent, ratification, and necessity. It wasn't, I mean, it was sort of ratification, but not really. So, okay, so it looks like James maybe was an agent through implied relationship. So James contacted some companies and James did find buyers. Peter contacted the customers, he made the deals, and then Peter asked James if James would like to continue being his agent, and now they signed an agency agreement. Now it's direct, express relationship. James asked for 10% of the recent sales, and Peter says that happened before James was agent, so he's not entitled to that money. So maybe we disagree with Peter on this. Peter ordered a large amount of raw silk and asked James to find buyers. James contacted some companies in America. One of the companies was interested in the silk and offered to give James a large cash bonus if he would tell them which factory was producing the silk. James felt uncomfortable doing that, but he also felt that Peter owed him money from the previous sales. To deal with this, James ordered a small quantity of silk from the factory to be delivered to his apartment. He then sold this silk to the customers to make up for the 10% that Peter had previously promised him. After making up the 10%, he continued to sell the silk for Peter. In addition, James sold some of the silk to his father's company, which made sleepwear for women. His father paid full price, so James didn't see any problem in making the sale. Okay, let's talk about this for a second. So James is now an agent, right? He was an agent anyway, but now they signed an agency agreement. So now he's definitely an agent. And now James is an agent, and one of the companies wanted to give James a large cash bonus if he would tell them which factory was producing the silk, but James didn't want to do that. So what did James do instead? Jody, what did James do?
I don't know.
Jordan, what did James do?
James ordered a small quantity of silk from the company, and from the company factory, and he's doing to his own apartment.
Why did he do that?
Because to get the 10% that he didn't give him.
Okay, so he wanted this 10%. So he
Yeah.
figured, okay, Peter's not going to give me that money, but he thinks he earned that money. So let me just make that 10%, and then the rest of that, I'll sell the silk for Peter. So that's one thing that James did. Then there's a second thing James did, which is he sold some of the silk to his father's company. Now, his father paid full price, so James didn't see any problem. Let's talk about these two things. So the first one, do you see any problem with this in terms of law, not
Yes.
common sense? Yeah, Florian.
Conflict for both of them, conflict of interest.
Okay, so definitely we're dealing now with duties, the duties of an agent. And maybe James broke some of these duties. So for this first duty, now that means we need to take a look at the duties that an agent has, right? The main duty is to carry out the terms of the agreement, but James is doing that. But here are the duties that an agent has. So good faith is the first one. Does it look like what James is doing is in good faith? Is selling the silk to his father in good faith? Jordan, you say no, why not?
Because he has to have the authorization of the boss.
But is James doing it to hurt Peter?
I think for me, I can see that, yeah, he's doing that to hurt Peter.
How does that
Because-
hurt Peter?
He's the agent of Peter,
Yeah,
and he has to inform him about the thing that he's doing in this company.
I agree. He should inform Peter, but I don't think he's selling it to his father to hurt Peter. He just thinks his father's another customer.
That does mean Peter lose money.
Why? His father's paying full price. He's not giving his father a discount.
Yeah, but this money, is it going to Peter? It's going
Yeah.
to Peter, no problem.
Yeah. His father's
that's no problem.
right. His father's just a customer.
That's no problem.
Well, it is a problem, but I don't think the problem is good faith. I don't think good faith is the problem. So what about this selling it to his father? He should tell James why. Is this appropriate behavior? Sure, no problem. Is he telling secrets? No problem. Is he getting a gift? No. Conflict of interest, though. That's a problem here. Why? So on the one hand, he serves Peter. Peter's goal is to get as much money as possible. But if he's also selling it to his father, now he has another interest, because really his father's not just another customer. You have a loyalty to your father. So of course he wants to give his father a good price. So there's kind of a conflict of interest there. What about that first thing where Peter took some of the silk to his own apartment and sold it? Is that good faith? Yeah, I agree. There's a problem here because you're breaking loyalty. If he wants that 10%, he should go tell Peter, hey man, I was your agent, you owe me that 10%. You should say that. You don't steal a little bit of the silk and sell it. Is there an outside benefit? No, he's not getting a gift. Competition? Yes. I mean, he is directly competing with Peter. Peter's selling the silk, and now he is selling the same silk. That's a problem. So he's breaking some duties there. Let's go back to the question. Okay, so, you know, there's some problems with this, there are some problems with this. When James' father receives the silk, he called James to say that the silk was low quality and not suitable for use in sleepwear. James was surprised and asked Peter, who told him that the silk was not as good as the previous silk. When James said that he should have been informed about this, Peter said, James's job is to sell the silk, not to ask questions. What do you think?
In order to sell, I must know more about the project. And
So what
actually,
is this called?
When you hide information, you're not supposed to.
So this would be a duty of the principal. So the principal, Peter, also has duties. Now, I think he's broken both of them. This is the duty to cooperate, which is the duty to give a disclosure of all information relevant to the business. And he had information that was relevant, that the quality of the silk went down, and he did not give that information to Peter. Then also the duty to reimburse. He needs to pay his agent, and he didn't pay him the 10%. So I think there's some problems there.
Also, sir, I don't understand in this study case when they say he bought the silk before to work with Peter. I don't understand this part. When you say before him, what is the timeline? What does it mean? Like, I don't understand.
The timeline, okay, so starting at the beginning, right now, James had not done anything at the beginning, right? Peter bought silk and told James, hey, if anybody could help me sell it, I'll give them 10%. But James had not done anything yet. Now, because of this, James went out and started to look for customers and found some customers. And then because of that, Peter saw, Peter then contacted these customers. Peter made the deal. Now, at this point, Peter should pay James 10%. Right? He said, anyone can help me sell the silk. I'll give them 10% of the profits. And James did help him. So James should get 10% of this. Now, they sign an agency agreement. So now it's James's job as an agent to do this. Now, James calls some companies, and now James gets a company to deliver some silk to his apartment. Does that make sense?
Yeah, I need to ask in the contract that they signed at a certain date, did they say that all of the sales are retrospective, which means like prior to this or no?
I don't understand what you mean. The silk is retrospective? I mean, I'm not sure I understand.
No, I'm talking about the contract as with the, okay, he has something, but then he made a contract with Peter.
It
He
doesn't
has for
matter.
10%, and then he made the contract. Once they
No,
made the
it
contract,
doesn't matter. He said, if anyone can help me sell the silk, I'll give them 10%.
okay.
Why do you think James went out and looked for companies?
For the money, of course.
That's it. He went out, he looked for companies because of the money. He found a company. He should be paid. It doesn't matter what the contract said. You know, James made a sale. He helped Peter make the sale. And Peter said, if anyone could help me make the sale, I'll give them 10%. He needs to give James 10%.
But sir, Peter can deny this because they don't have evidence like written paper or something.
But the evidence is clear. The evidence is James went out and contacted companies. Why would James do that?
Yeah.
I mean, why would you do that kind of work unless you thought you were going to get paid? And anyway, there's plenty of evidence. Peter contacted these companies and made the deal. As a lawyer, you could just call the companies and say, who contacted you first? And they would say, oh, this guy, James. All right. I mean, this won't be hard to prove. So this is, but you know, you guys are, again, you're talking in common sense and not in the law, which concerns me. You know, I want to know, what is agency? How is agency created? What kind of agency relationship do they have? And then the duties of an agent. You can't just start talking about the common sense. Okay, there's one more part to this. So we said James' father received the silk. The silk was low quality. And when Peter confronted James, Peter said, your job is to sell the silk, not to ask questions. Now, and we said Peter has broken his duty as a principal. One day, when Peter was away on business, James found that there was a leak in a water pipe in the storage room and the boxes of silk were getting wet. James didn't know what to do, so he tried to contact Peter via phone, WeChat, text, and email. Peter did not respond. There was no other place to store the silk, and it was getting more damaged every day. So James contacted a customer and sold all the silk at a reduced price. When Peter came back to the office, he was furious about this and fired James on the spot. And here were the questions. Has James broken any duties as an agent? Has Peter broken any duties as a principal? We already looked at these. And could James have a cause of action? Again, this means a reason to sue someone for being fired this way by Peter. So what happened in this part? James is the agent. Can anybody tell me the legal version of what happened here?
The duty to provide information.
Well, but James tried. James tried to contact Peter.
Not from Peter, not from James, but Peter's side. He didn't respond.
How could but that's, you don't have a duty to respond to text messages.
This is like the James Act on behalf of Peter, but I forget the legal name of it. But I know that's not force majeure, but it's like the Peter would lost everything anyways. So yeah.
Okay. So
it looked like the Samaritan law.
This is called necessity.
But it looks like, right?
I guess, but the Samaritan rule doesn't relate to property.
Yeah, it's for civil law.
You know, this is called necessity. And this is one of the ways you can become an agent, right? We talked about the creation of an agency relationship. At first, James was an agent by implied agent agreement. Then he became an agent by express. And then finally, at the end, he was already an agent, but he used necessity. So necessity is this situation where there's an emergency to property, and it belongs to the principal, and it's necessary to act to protect it, but you cannot communicate with the principal. So in that case, the agent has the right to make deals to protect the principal's property. So he couldn't be fired for this. Anything else? No, that's pretty much it for agency. The only other thing we didn't say is if the if the agent broke a duty of care, like Peter broke these duties, I'm sorry, not Peter, James. James broke these duties. So what did James break? Right, there were two things James did. One, he sold some of the silk himself, and two, he sold some to his father. Are there any damages here that Peter could get back? Harry or Tiffany?
No.
No? Peter made money, and James took some of that money. James sold the silk himself. Do you think Peter wanted him to do that?
I don't know.
Well, thank you for telling me that. Harry, what do you think? Did Peter want James to have some silk delivered to James's house that he would sell secretly?
No, of course not.
Of course not. That's not something he'd want. Can Peter get that money back?
No.
Why?
He has.
course
You
we
need
can.
to prove it. It's like you need the
Oh my
proof.
God, we didn't learn evidentiary law in this class. There, you don't have to worry about proof. Assume you can prove it. It's so easy to prove these things. I mean, literally, you just check the order at the factory. They delivered it to his apartment, and then Peter had made money and put it into his bank. We can get records of all of this. It's so easy to show. This is not hard evidence. Sir, what if the agent doesn't do anything in terms of necessity, not making deals to save the silk? Does Peter have a cause of action? Good question, Isaac. No. The agent does not have to do anything. His job is not to protect this. So there is no good Samaritan law that says you have to. You know, because he did what he could. His obligation was to contact Peter. He did. He sent him WeChats and text messages and emails, and he did his best to contact Peter. Now, Peter didn't check his messages and reply? Okay. You know, that's on Peter. So no, James had no responsibility to take care of it, which is why he shouldn't be punished for trying to help. But this 10%, absolutely, Peter can get it back. If an agent has broken a duty, the principal's remedies, the principal can recover money lost from the agent's breach. The principal can recover any profits wrongfully made. That would be that 10%. But of course, at the same time, Peter probably needs to pay the 10% from the first sale. So it's kind of going to balance out. Okay, that's it for agency. Now, our last question was about employment
Did
law.
we gonna have this in final exam?
Yeah, absolutely, you will have this in the final exam.
Okay.
We learned it in class.
Yeah, I know.
I guess that's not good. Yeah, well, this is why I said if you need more practice questions, tell me, and I'll make more or I'll put more up. But mostly what you need to do is get your materials together.
Please put more. We can do that.
You want more? Okay, I'll try to put more up. Okay, Veronica has a successful clothing store in Shanghai. She hired Mary to work in her clothing store. Mary's young and attractive, and all the men who come into the store pay attention to her. This makes Veronica feel jealous. Also, Mary has been using her employee discount to buy clothes for her friends. Veronica wants to fire Mary, but she doesn't know if any of this is a good enough reason. So instead of firing Mary, Veronica tells her that she needs to start coming to work at 6 a.m. to clean the toilets. She can only have 15 minutes for lunch, and she must eat lunch in the back room of the store, which is very dusty and has no windows. Every day, Veronica insults Mary, telling her she's stupid and she'll have stupid babies. Finally, Mary has a breakdown, starts crying in the store, and quits without notice. Could Veronica have fired Mary fairly? How can Mary sue Veronica? And what would be the other forms of dismissal and their remedies? So Mary is the employee and Veronica is the boss. Veronica wants to fire Mary. Now, can Veronica fire Mary fairly? So to understand this, we need to understand, what is fair dismissal? How do you fire someone fairly? Well, we know there are three things you need to do. You have to have a good reason. You have to act reasonably, and then you need to give notice. These are the three things you need to do. Everybody understand what this means, give notice? Right? Tell someone in advance. So what about the reason? What are the good reasons to fire someone? Well, there are 6 reasons. Maybe you can't do the job. You just don't have the ability. Or you have bad behavior. Or we don't need you anymore. Or you broke a law. Or your retirement age. Or any other good reason. Now, why did she want to fire Mary? She kind of had 2 reasons. What were the 2 reasons for wanting to fire Mary? Tiffany, what are the 2 reasons?
Those were not reasonable.
Well, but what are the reasons?
Okay. According to Veronica's opinion of Mary, she is too attractive for her liking, and that Mary is buying too much clothes using the employee discount.
Why is she buying clothes with the employee discount?
To gift it to her friends.
Is that okay?
That is entirely okay.
Okay.
No.
Well, I think that's a good point because there is going to be some disagreement. Some people will say yes. Now, in Veronica's opinion, do you think Veronica gave Mary the employee discount to buy clothes for other people or for herself? Well, I mean, I see Tiffany's point. Veronica didn't say these can only be clothes for you. But
That's implied.
oh, maybe it is and maybe it isn't.
It's simple. The
Well,
discount is on which account, which client's account. That's it.
So, I mean, Tiffany, if you own let's say you own a clothing store and you discover that your employee, Harry, all of his friends are giving him money to buy things from your store with the employee discount. So he is essentially almost like he is a coupon. It's not like now I understand your point, Tiffany. If Harry bought some clothes to give to his family as gifts, no problem. But what if there's all these people around going to Harry and buying clothes from your store? On the one hand, you are making money. On the other hand, you're getting like a 20% discount to everybody Harry knows in his whole university. It's a hard call. Now, could Veronica fire Mary for using the employee discount to buy clothes for her friends? I'd say maybe. It's not a definite no. It's not a definite yes. It's a maybe. I think she has an argument. Depends on, I think, like Florian said, it depends on how much clothes she buys. If she's buying like 20 pairs of pants every single week, I mean, there's a question there. What's going on? But as we said, to fire someone fairly, you need a reason. Then you need to act reasonably. Did she act reasonably?
No.
Who?
No, she did not.
Mary or?
Right? She said you have to clean the toilets. Mary's job is to sell clothes. Why does she have to clean the toilets? Why does she only have 15 minutes for lunch? Why does she have to eat lunch in the back room of the store? And you can't tell someone they're stupid. That's totally unfair. And because she's treated Mary unfairly, what could have been a reasonable dismissal is now an unreasonable dismissal, I think. How can Mary sue Veronica? So the first one, could Veronica have fired Mary fairly? Well, we talk about, what is fair dismissal? What is unreasonable treatment? What are the fair reasons? After discovered reasons, you should talk about also. If you have extra time, I would not say you need to write all of these. But, if any of them are broken, did Mary break anything? Did Mary break mutual trust and confidence? If she was selling these clothes to all kinds of people, maybe. Maybe she did. The duty to faithfully serve the employer, maybe she broke that. But she probably didn't break anything else. What about Veronica? Did Veronica break any duties? Yes, she did not show respect. She called her stupid. That's it. Well, this health and safety, maybe. Telling her to eat lunch in this dusty back room with no windows, maybe. Hi, Jordan's dog. Jordan's dog. Aw. Hi. Okay. Unfair dismissal, you have to work for at least 1 year. And then the band of reasonable responses test in our case. So whether Veronica could have fired Mary depends on two things: whether you had a good reason and whether you acted reasonably and also was proper notice given. Mary was using her employee discount. I think this does violate the implied duty of trust. So it's possible this could have been a fair reason, but Veronica treated Mary in an unreasonable way. So the fair dismissal would become unfair. And for unfair dismissal, we're going to use the band of reasonable responses test, which says, would any employer in the whole world, any reasonable employer, fire an employee if they use their discount to buy clothes for other people? Maybe.
No.
So I think it would probably pass that test. And so she would be allowed to fire Mary, but she didn't. She acted unreasonably, So what about the second case? Can Mary sue Veronica? Can Mary sue Veronica? Definitely, with constructive dismissal, right? This is the idea that she made Mary's life so difficult that Mary could not continue and she had to quit. Mary had a breakdown. You can't do that to someone. So we understand that it doesn't matter if this was one big thing or a bunch of little things. And then the remedies are the same as for unfair dismissal. So there are 3 remedies for unfair dismissal: reinstatement, re-engagement, and compensation. So does Mary want to get her job back? No, I'm sure she does not want her job back. Does she want to get a new job with Veronica? No, unless Veronica has many, many stores. Maybe Veronica has another store in another part of the city and she doesn't work there. Maybe. Probably what Mary wants is the money damages. So we know there are 3 kinds of money damages. There is the basic, compensatory, and health and safety award. Basic award is just because Mary lost her job. Compensatory award is while you wait to go to court, the time that you lose. And health and safety whistleblowing is not a problem here. But the basic award is your loss of job security. Your compensatory award is waiting to go to court. But of course, you have a duty to mitigate losses. So Mary does need to look for another job. What does that mean? Can someone explain that to me? Junpyo, can you explain this to me? The employee has a duty to mitigate losses.
So not just asking for the boss to give her like $10 million, she has to find something and to make up the losses she have.
Well, let me ask though, why would Mary, Mary is a salesperson at a clothing store. She certainly doesn't make $1 million a year. She could never ask for that. You're talking about, that's the basic award. She lost her job, right? Now, the amount she gets is going to depend on her age, how long she's worked, and how much money she makes every week. She couldn't ask for $1 million. You know, if you work at a very like reasonable job, you can't ask for millions of dollars. But what about this, the compensatory award? This is where there's a duty to mitigate. Any thoughts, anybody?
Because like she will not earn during a certain period of time, is like.
So what does she need to do?
Gave her a notice before.
I mean, what does Mary need to do? That's the employee.
Negotiate a contract.
She needs to look for a new job.
Oh.
This is the idea of just sitting at home and never looking for a new job. That's where it could be $1 million, right? It wouldn't really be $1 million, but let's say Mary, you know, is supposed to get, I don't know, she's asking for $5,000 a month. That's what she's asking for. $5,000 a month. Now, could she sit at home for 6 years and then sue for, you know, hundreds of thousands of dollars? No, she can't do that. You know, she could sue for, if it takes her 3 months, 6 months, maybe a year, but she has to prove she's looking for a job. Because what if she could get a good job? Then it's no fair. I mean, the point is to give her a job. Now, she could also try to sue for the Health and Safety Award, and that has no limit. She could try to say that you put me in the back room or you made me clean the bathrooms and that was bad for my health. She could argue that, or her lawyer could argue that. What are the other forms of dismissal and their remedies? Remember, I want you to also know the remedies for each form of dismissal. So we already talked about fair dismissal and unfair dismissal. Now for fair dismissal, if I fire you and it's fair, it's fair. There's no remedy because you did something wrong, or you had bad behavior, or you couldn't do the job, or you were retirement age, or whatever reason. I fired you, that's fair. There's no remedy. For unfair, you know, we already looked at unfair dismissal. Unfair dismissal, you have to work for 1 year, and it could be based on anything that makes it unfair. And then we look at this test, the band of reasonable responses test, which said, would a reasonable employer, could they have acted in the same way as the employer who dismissed the employee? So would any employer in the whole world have fired you for this reason? And the remedies are these three: reinstatement, reengagement, and compensation. Now, what are the other kinds of dismissal? Fair dismissal was, we already talked about. Unfair, we already talked about. Constructive, we already talked about. Automatically unfair, there are these 6 reasons you can never fire someone. And then wrongful. And wrongful is like unfair, except it's common law. And the differences are there's no time requirement. Even if you only work for 1 day, you could use this. The burden of proof is on the employee, so it's harder to prove. You could go to the court or the tribunal. And you can also use after discovered reasons. What's an after discovered reason? Can somebody tell me that?
When your boss find out a mistake or a fault that you did before and try to punish you for this now.
Sure. So the boss fired you and then found out a better reason. Does that make sense?
Yes.
So the boss fired you today with a bad reason. But then later they find out a better reason to fire you and they say, oh, you're fired because of the better reason. They can't do that in unfair dismissal. But in wrongful dismissal, they can do that.
So what is the difference between? Oh yeah, I see what you mean. Yeah, I got it.
So wrongful dismissal is harder for, if you're the employee, wrongful dismissal is harder for you to prove because you need to prove, you have the burden of proof. You need to prove that you were fired unfairly. And because you need to prove that, I can look for any reason that you should have been fired. And you have to prove that it was unfair. With unfair dismissal, I have to prove that you were fired fairly. I have to prove you did something wrong. So unfair is going to be better if you're an employee. However, you need to work for 1 year to use it. It was created by the government because wrongful dismissal is hard to win. Why do we have this 1 year requirement? Tell me what you think, Harry. What do you think? Why? Why have a 1 year requirement? Why not make it a 1 day requirement? Any thoughts?
So they have to work for a year before they can do what? Sorry.
Before you can use unfair dismissal. So let's say, Harry, that you work for me and I fire you. And I fire you for a not good reason. You know, I fire you because every time I see you, you call me Dave, but I want you to call me David. And it makes me angry, so I fire you. Now, that's not a good reason to fire someone. I should have just talked to you. But instead, I just fire you. Now, let's say I give you notice. I say, Harry, you're fired. I'm giving you 1 month notice. But you think that's a bad reason, and you want to sue me. Now, if you've worked for me for even 1 day or 2 days, you can always use wrongful dismissal, no problem. But the problem with this is that you have to prove you were fired unfairly. Now, if you go to court and you say, you know, David fired me and I don't know why, I have no idea why David fired me. You know, and I say, oh, it was because Harry came late every day. Whatever, you know, whatever I say, I could lie. It's going to be hard for you to prove this. But with unfair dismissal, I have to prove that I had a good reason to fire you, which I did not. And so I'm going to lose this case. But you can't use it unless you worked for me for 1 year. Why? Why not let you use it after 1 day? Why 1 year? It's a hard question.
Yeah, maybe it goes to about like the time frame, like you said, you can't really prove. Maybe
What could happen if you came to work just for a couple days and you decided you hated me or you just didn't like me? I'm the boss and you just didn't like me. If there was no time requirement, you could go to court or you could sue me for unfair dismissal. Let's say you come to work for 2 days and you don't like me. You could immediately sue me for unfair dismissal, and I would have to prove that I fired you fairly. It's hard for me to prove, but you could use this as a way to attack me.
Sorry, you mean like the people must be at least 1 year in the company?
Yes.
To apply for unfair, right?
Yes. Because then you're not very likely to use this against a stranger to attack them. You know, putting the burden of proof on the boss, it's a big thing for the law to do. To say that the boss has to prove that you were fired fairly. You know, and you could easily use this to attack me. And with unfair dismissal, I can't use these after discovered reasons. So I can't even look for some other reason now. You could just work for me for 2 days and then say David fired me. And it would be a great way to attack me. And so the law says you have to work for 1 year before you can use this because it's very powerful. Okay. Remedies are damages and injunction, and you have to mitigate losses. Here are the differences between them both. Redundancy, you don't have to know that, and then that's it. So that is everything. I can try to put some more practice questions or practice test on so you can take a look at it. Now, the only thing I would say, so this is our last class. The final exam is offered next Monday. I'll put it up from 12 to 12 noon to midnight. If anybody needs it, as I said, at a different time, if there's some problem and you can't take it on Monday, you need it earlier or you need it later, yeah, please WeChat me and I can make a special concession. Otherwise, it will be available next Monday. If you guys would like to have another review class, that's possible also. You know, I'll put up like maybe 2 more tests. I won't put up questions. I'll put up actual tests from the past so you can see what they look like. And if you guys want to have another review class, I'm pretty flexible on time. Pretty much any morning Beijing time is okay for me. So, you know, and if only 2 of you or 1 of you want to do it, that's okay too. You know, don't feel like you need to get a bunch of people together. If 1 of you wants to have a Zoom discussion, that is cool. I want you guys to do well on this final. You know, it's a very small price for me to pay to have an extra class for an hour or 2, and then, you know, a bunch of you do better on the final. Like for me, it's just an extra hour or 2. It's not a problem at all. So don't feel like you don't want to ask. Isaac, are you saying something? No? Okay. Okay.
When you say from noon to midnight, Beijing time, right?
Yes.
Got it.
Okay, well then if I don't see you guys again before the test, good luck on the test. It was great to talk to you and have this class over Zoom. It would have been more fun in person, but hopefully we will meet again in the new year. I'll look forward to that. And yeah, don't get any lawsuits before then. If you do, let me know.
Thank you, sir.
Okay,
Thank
bye,
you so much.
guys.
Thank you for your time and everything.
No problem. Oh, let me turn control over as I do my last time. I'll give it to Jody.
You never gave it to Jordan.
I never gave it to Jordan. Jordan gets it then. Okay, Jordan. Jordan is now the host.
Thank you, sir. Thank you.
Okay, I'll see you guys soon. Bye.
Okay.
Bye.